When asked if CETA meets the requirements of the Constitution, the International Trade Minister Chrystia Freeland said absolutely. I got another quote here. The University of Ottawa constitutional law expert Errol Mendes says you're going to lose this one. It's been long established that the Constitution gives the feds the right to sign and ratify treaties, just as it can deploy troops overseas without Parliament approval. Do you care to address that?
Well, firstly, on the Trade Minister's elaborate explanation of why it's constitutionally valid as to what the federal government is doing, absolutely doesn't cut it for me. I don't know what she's basing her off the cuff response on. With respect to Professor Mendes, and I say this with all due respect to all professors who live in a secluded environment of academic discussion.
We call them ivory towers.
Well, I was trying to be kind, Paul. With all due respect, if I had $100 for every time somebody said that my cases didn't have a prayer, I wouldn't have to, ask my clients for money for representing them on those cases. The fact of the matter is that prior to the Harper government engaging in negotiations on the CETA, the Parliamentary Research Library was asked to do a paper on the source of the constitutional authority for signing treaties, of which I have a copy, because this is the third time I've raised this issue in the court since 1998, and the first two times it did not get resolved by the courts to its conclusion. What that research paper from Parliament, which was floated to the government, states is that this whole notion of constitutional authority to sign treaties by the executive is in flux, and they stand on the old prepatriation notion of residual crown prerogative. Back in the days when Westminster in England, the executive, Her Majesty the Queen, used to sign these treaties on behalf of all the dominions. That evolved in 1935 to allowing the Governor General, as her designee here in Canada, to sign on behalf of Canada. What's happened in my view, and with all due respect to Professor Mendes, who's probably never thought about it, is that the patriation of the Constitution extinguishes residual crown prerogative, which is the power in the Queen to exercise power that Parliament or the Constitution has not taken over. The House of Lords in England has made it clear that Her Majesty the Queen has no more role in Canada. So, in 1998, in a case called Fogel that went to the federal court where the same issue was being litigated, the government moved to strike the claim based on the fact that this was a frivolous argument, this idea that the executive didn't have the right to sign international treaties. The court refused to strike it on that basis, and in the written judgment said whether or not crown prerogative still exists after the patriation of the Constitution in 1982 is a serious question to be resolved. The court didn't hear the case because in the context of multilateral agreement on investment, which was the case, the agreement was not ultimately signed by the Canadian government nor the other 28 OECD countries, and therefore the case, the court decided they weren't going to hear it because there was no treaty. However, on the issue that we're putting before the court, the federal court has already decided that this old notion of whether or not crown prerogative exists to give the executive the authority to bind Canada this way is a serious question to be determined by the court. Now, is there a guarantee we'll win? No, but I stand firm on the representation that we're on solid legal ground here. You cannot have the executive knowingly sign away provincial rights with respect to provincial programs and provincial property in Canada and have a foreign body come to Canada and decide the rights of the province and of Canadian citizens under domestically, including constitutional issues, and not have our courts have a say in it. I mean, how ludicrous is that?
And if I might add, the same argument applies to federal rights, including the unlimited jurisdiction of the Parliament of Canada over money and banking, which would be compromised by the treaty and would be in effect rendered ineffective so that we couldn't use an asset which is our most precious financial asset in the whole country.